I call Kennedy Graham.
Thank you, Mr. Speaker. I must say that it is with considerable sadness that the Green Party rises to address this bill, at least in the sense of the way that developments have arisen in the last few months, because we did initially enter this exercise with the intent of supporting the bill. We certainly supported it in first reading into Select Committee, and I think, as has been established by both government members and Labour Party opposition MPs, that constructive spirit worked its way through pretty much the whole of the hearing in the committee. The problem that arose is that it became apparent that there is this one, what I would suggest is fatal defect in this bill, and it is a very narrow one, but it strikes very deeply. And if it is only 1% of the text of a bill, it is with great sadness it would have to go very deep for any party to oppose it. I put it to the Minister and government members that this is a case in point. And I do so with sadness, and I also do so in hope, because I don't believe that it is too late to change one minor but fundamentally important point. We are not talking, sir, about civil trials. We are not talking about the procedural dimension of criminal trials. We are talking about simply substantive trial of a criminal case. And in that context, we are only talking about the rights of a defendant. We are not talking about whether witnesses, at least the Green Party is not, talking about whether witnesses should or should not. We are prepared to see witnesses in substantive criminal trials submit by AVL. What we are not prepared to see, and what we suggest is a fundamental tenet of common law systems in New Zealand, the UK, Australia, Canada, United States, is the right of the defendant to be physically present in the substantive hearing of a criminal case. So that is an absolute principle that cannot be measured in terms of dollars saved. I reach for the various authorities on criminal law, and I look up in absentia, and I see the following: in absentia in common law legal systems. In common law legal systems, conviction of a person in absentia, that is, in a trial in which they are not present to answer the charges, is held to be a violation of natural justice. Specifically, it violates the second principle of natural justice, audi alteram partem. By contrast, in some civil law legal systems, trial in absentia is permitted. There are various cases cited. If we look, and I understood the Minister to cite New South Wales, I think, Victoria, UK. I do not think that that is a fundamental tenet of the judicial system, the criminal law system in those countries. I look to the United States, the Constitution and cases in 1844, reiterated in 2004, where the principle of natural justice is held to be inviolate when it comes to substantive hearings of a criminal nature. And I think we need to be very careful how we proceed from here, because I do see from a release on 3 June that the government has already released $2 million to, quote, roll out the AVL system throughout the courts. I see the Minister, in introducing the second reading, was drawing a distinction, and I think it's an interesting distinction between effective participation and physical participation. Sir, I would respond that the only effective participation in a substantive criminal trial is physical participation. That is an absolute principle from which one cannot derogate. We have to understand the defendant in almost every case is in a weak position. If you cede the absolute nature of that principle, you have essentially taken away the fundamental protection that the defendant will have in such a trial. You are farming out that protection to a decision by the judge or the registrar. To what end are we doing this? What is the rationale I asked the Minister, and I looked to him to reply in the fullness of time, what is the rationale for ceding the absolute principle of the right of the defendant to be present in a criminal trial? What is it that has changed so seismically in our system that there is a justification, an explicit, transparent justification to do that? What are the reasons? We are told that it is, quote, improved efficiency, cost savings, increased safety, increased access to justice, and improved quality of evidence. Sir, cost savings? To take away the absolute right of the defendant to be physically present? What price do we place on that? What dollar figure do we place on that? $100,000 for one miscarriage per year, discounted to $150,000 for two? How much are we going to save? And how do we look around and tell our citizens, and indeed our children, that it was worth it to take away this price because we saved a few $100,000 in vote justice? Let us put it to the test in the legislature, or indeed in the executive. Let us suggest that the Cabinet meet by AVL for a 6-month period. The Minister of Justice and the Prime Minister would not be present. The others could, but the Minister of Justice can participate in Cabinet decisions, including his own portfolio decision-making by AVL from his electorate. No need for him to be physically present. It'll save cost. Let us see what happens with the body language when he is not present. We've heard suggestions as to what you do and do not pick up from one angle of the camera. To suggest that a defendant can be completely comprehending what is going on in his or her murder trial by watching from 100 kilometres distance from one camera. Is the judge winking? This can be rectified, I hope, in the committee stage. We are not against the advance of technology in introducing AVL. We support the bill in its thrust, with the single narrow exception of the right of the defendant to be physically present in the substantive hearing of a criminal trial. It will not take much for the government to cede a point on this, and I hope that pride does not get in the way, because we are talking about striking at the fundamental heart of our criminal law system. If that is not done, then the Green Party will reluctantly oppose the bill on that sole point alone, and as a signal of our intent, we will oppose the bill on this second reading. But in the event it is voted through into committee of the whole, we shall work constructively to see if we can clarify that one point so that we can resume a positive vote for it. Thank you.
I call to Uro Flavel.
Kia ora, Mr. Speaker. Tēnā tātou